These appeals are at the instance of the Chief Revenue Controlling Officer of Registration and two other revenue officers seeking to challenge the judgment and order passed by the High Court of Judicature at Madras, by which the High Court allowed the civil miscellaneous appeals filed by the respondent herein under Section 47 of the Indian Stamp Act 1899 and thereby quashed and set aside the order passed by the Chief Revenue Controlling Officer of Registration with respect to the stamp valuation. The subject matter of this litigation is the valuation shown in the two sale deeds registered as doc number 487 dated 5 September 2002 and 488 dated 2nd September 2000 respectively. The respondent herein is the purchaser. He got the two sale deeds executed through the original owner of the property in question. The market value of the entire property covered in both in sale deeds is rupees 1,20,000 and rupees 1,30,000 respectively. It appears that the joint sub-registrar Trivandrum, on receipt of the two registered sale deeds, declined to release the documents on the premise that the sale consideration shown in the two sale deeds was undervalued. The matter was accordingly referred by the joint sub-registrar to the special deputy collector under bracket stamps under section 47A of the Act for the purpose of determining the correct market value of the property. It also issued notice in Form I fixing the value of the properties in DOC number 487 by 2002 at rupees 45 lakhs and property in DOC number 488 by 2002 at rupees 13 lakhs respectively. The special deputy collector under bracket stamps on conclusion of the inquiry fixed the market value of the property covered under DOC number 488 by 2002 at rupees 10 lakhs and the property covered under DOC number 487 by 2002 at rupees 51 lakhs. The respondent herein being dissatisfied with the order passed by the special deputy collector under bracket stamps preferred a statutory appeal before the Inspector General of Registration. The appeal came to be dismissed. In such circumstances referred to above, the respondent herein went before the High Court by filing civil miscellaneous appeals under section 47 under bracket A of the Stamp Act. The High Court allowed both the appeals and thereby quashed and set aside the orders passed by the authorities below. The appellants, feeling satisfied with the impugned judgment and order passed by the High Court, have came up before this court with the present appeals. We have heard the learned counsel appearing for the appellants and M.S. Rosni Musha, the learned counsel appearing for the respondent. We take notice of the fact that the High Court, while allowing the civil miscellaneous appeals, has observed in paras 20 and 21 respectively as that being the legal position, if the contention raised on the side of the learned counsel appearing for the appellant is appreciated in the legal position as above laid down by the Supreme Court, full bench, division bench, and single judges of our High Court, it would compel this court to hold that the proceeding referring the documents for determination of the market value without recording any reason to say that the document is undervalued, thus without performing the statutory obligation cast upon the third respondent registering officer to record such reasons to arrive at the decision that the documents are undervalued and the same are required to be referred to the authority concerned to determine the actual market value of the property is contrary to the procedure laid down under law and is totally illegal. Furthermore, no material is made available to show that the third respondent registering officer on the basis of such material arrived at the conclusion that the true values is not set forth in the documents. In the absence of one such material, the proceedings initiated under Section 47A is legally unsustainable. As such, the proceedings initiated for determination of the market value and the outcome of such proceedings fixing the value of the property covered under doc numbers 487 and 488 by 2002 at rupees 500 per square feet and rupees 95 per square feet respectively, and demanding additional stamp duty on the basis of such exorbitant value fixed, is hence arbitrary, bad in law and null and void. In the case, the documents were registered whereas from I notice was issued. However, from I notices did not reflect the reasons for which the value mentioned in the documents was treated as undervalued and the material based on which the value mentioned in the documents was enhanced. Further, the orders of the second respondent, especially Deputy Collector dated 12 October 2004, did indicate the basis on which the value mentioned in the documents in question was enhanced.